So there's still a couple other things, though, that I want to point out regarding this case. The first, there are some other implications and impacts that this decision has. Most notably, obviously it makes clear that you cannot have subjective criteria for the issuance of a CCW. That criteria must now be objective and clear and concise, and one in which it's easily understood, so it's no longer going to be subject to this wide discretion that good cause is typically given issuing authorities to do in terms of deciding whether or not to issue a CCW. The Bruen decision also made clear that it does apply, and it makes, I should say, the Second Amendment applies to modern firearms. And this was something that was already addressed in Heller, but the court took the step of reiterating this point because obviously you hear, well, the Second Amendment should only apply to muskets and other, nonsense from those that are, against firearm rights generally. And the court is reiterating that point that was already made clear in Heller and making it clear here again that the Second Amendment does apply to anything that constitutes bearable arms. And that is something that if you're regulating bearable arms and it interferes with the person's rights guaranteed by the Second Amendment, that is going to be subject to this new scrutiny that the Bruen case is sort of laid out. And of course, as I've already mentioned, really important here is that this two-step test that's being used historically is now basically thrown out, and courts are now going to have to apply this new standard. A couple notes on some of the related opinions. So in Bruen, in any Supreme Court case, oftentimes you'll get secondary opinions in addition to the majority opinion. Now, the majority opinion is the sort of controlling opinion. And so when it comes to saying, what is actually setting the precedent, it's that majority opinion. But oftentimes you'll have what are called concurring opinions, which aren't necessarily setting precedent, but raise other issues or address questions, things like that, to help sort of explain further potentially the majority opinion, or highlight potential problems with it. And so in this case, we had first a number of concurring opinions. The first one was from Justice Alito, and his concurrence is basically a direct response to the dissenting opinions, which I'll talk about here in a bit. And basically pointing out that all the Bruen case is making clear today is that the New York statute is unconstitutional, and we're establishing this framework. It doesn't call into question directly any other specific law or regulation. That's something that has to be analyzed under this new standard by a lower court first before it could potentially come back up to the Supreme Court again, if it does. And it also, of course, points out that in the dissenting opinion, which I'll just talk about right now, I guess, you had Breyer, Kagan, and Sotomayor, all of which joined this dissenting opinion because it was a 6-3 decision, six in the majority and 3 in the dissent, that basically pointed to all these statistics of gun violence that they call, something that, to highlight how, and to basically the dissent was trying to argue that, look at all these things that we deal with. It's improper for us to use this new standard without considering government interest, because they really want the government interest to be relevant, because, as I said before, it basically gives the government extreme deference in any sort of regulation that comes about. And of course, for reasons that I already discussed, that shouldn't be the central question in any constitutional right issue. And so his opinion, Alito's concurrence, basically just as a direct response. The second concurrence was co-authored by Justice Kavanaugh and Justice Roberts. And basically what this concurrence does is it sort of reiterates the points in Heller. Again, it quotes directly from Heller and makes clear that this new framework that's being adopted, while arguably very difficult for the government to satisfy, there are still a variety of regulations that are appropriate even under this standard. Now, they don't go into specifics as far as what those regulations are, because again, that was an issue in the case in Bruen. And so these questions, again, are going to have to get relitigated at the lower courts first to determine whether or not a particular law is in fact constitutional under the new standard. And lastly, we have Justice Barrett, who issued a concurrence. And what Justice Barrett's concurrence really talks about are sort of unanswered questions that the new standard arguably raises. Now, it's more technical as far as, you know, what as far as the standard itself, and it's more legally focused rather than, you know, on a particular law or issue, that kind of thing. So I'm not going to go into it in too much detail, but basically she's just highlighting potential issues or problems that could arise in future cases as a result of this new standard. Whether or not that will actually become a problem remains to be seen. Admittedly, when I first read the decision and I read her concurrence, I couldn't readily think of anything that would raise that problem, but who knows? It remains to be seen. And so she raises it, obviously, and wants to, you know, make the point that this is a potential problem or a potential issue that could come up in the future. And so, of course, I've already talked about the dissenting opinion, which, again, is a dissent. So as a dissent, it does not have any precedential value, meaning it's not something that generally can be relied upon moving forward. But nevertheless, of course, Justice Breyer's dissent largely mirrors that of his dissent in Heller and McDonald. So it was no surprise that he voted the way that he did, and nothing new with his dissenting opinion. But a lot of his stuff, as Alito points out, isn't really relevant for the purposes of the discussion, because the government interest is no longer something that's generally considered by courts moving forward. So some particular points of fallout regarding the Bruen case. First and foremost, in California, the California Attorney General has already made clear to CCW issuing authorities that they can no longer enforce California's good cause requirement. So if you were on the fence before, or you were unsure, now is the time to apply for a CCW. Now, obviously, we're going to be going through some growing pains here in California, particularly in issuing jurisdictions that were previously very restrictive may-issue jurisdictions are now going to be forced to adopt this new standard that says they can't use good cause, and it has to be objective criteria. So that could take some time, but nevertheless you should apply, because there's no basis for them to deny you for lack of good cause moving forward. I will say too, I've had some questions from people on, for example, what if they were recently denied for lack of good cause. I've had someone that was denied like literally 3 days before the opinion came out. Well, in that situation, you may still be able to appeal that denial. So you need to check with your issuing authority and what policies they have that would allow you to potentially appeal that. And presumably, if you appeal within an appropriate time, there's no basis for them to deny you that appeal. And by appealing that, of course, you're potentially preserving your quote-unquote spot in line, because you should then have priority when it comes to getting a CCW, because we are, of course, going to be expecting a huge influx of CCW applicants as a result of this decision. And some jurisdictions are already starting to feel that. And so I've already sort of briefly talked about the standard. that's been imposed by Bruen now for Second Amendment cases that has already had some impact on a number of cases, in particular the Duncan v. Becerra case, Young v. Hawaii, Rupp v. Becerra, challenges to California's quote-unquote large capacity magazine restriction, the Hawaii good cause requirement, and of course California's assault weapons ban, as well as a number of other cases here that are now moving as a result of the Bruen decision. So stay tuned for that. I'd encourage you, if you have not already, subscribe to the CRPA email alerts so you can get updated on what happens in these cases and others, but also just to generally stay informed. And also, if you're looking to apply for a CCW and you have questions on the process, you can always reach out to CRPA directly. But more importantly, guys, you guys need to support the CRPA. They're the ones that are definitely leading the fight here in California. So I will include links in the description below to how you can support the CRPA, including becoming a member and or potentially donating to their fight here in California. In the next video, I'm going to talk about some of the other issues that have come up post-Bruen, legislative issues in particular. And then, of course, I'll be doing other videos on DOJ's release of gun owner information through their firearm data portal. So be sure to subscribe to the channel. See you guys on the next ride.